Squad, Yonathan Elias here with Spar and Bernstein partner and personal injury attorney, David Levy. David is joining me to discuss a recent case in which he was able to win a settlement of over $600,000 for a client who fell on the job and was severely injured. All right, welcome. How are you doing?
I'm doing good. Good to be here. Happy to talk to you about this case.
Awesome. So let's get into it. What happened in this case?
So we represented a boiler technician. He was called in to repair a malfunctioning boiler on a residential building in Brooklyn. There's about 24 units in the building, and for whatever reason, their boiler was having issues making loud sounds, failed to provide heat sometimes to the tenants, and he was called in to basically diagnose the issue and to fix what was wrong with it. He was actually an employee for the company that was called in to repair it.
Okay, so what were his injuries?
So what happened was while they were in the process of figuring out the problem with the boiler, these residential boilers, they have what's known as a pit where water is drained from them and the excess water flows into the pit. That water in the pit, which is about 2 feet wide and 2 feet deep, that water is also then pumped out, and generally it's a very, very smooth system where water flows from the boiler into the pit, into the pump. While they were draining the boiler, and just keep in mind, this is the coldest day of the year. It's in February. It's about 0 degrees outside, and there's a whole building without heat because they're trying to fix this thing. He's draining out about 1,000 gallons from this boiler, and out of nowhere, the water starts overflowing from this pit. They stop draining it to try to figure out what's going on, and the water starts rising out of the pit and onto the floor. Now, the temperature of that water was anywhere from 200 degrees Fahrenheit to 300 degrees Fahrenheit. So it was boiling hot. Another thing was that pit, according to the New York City plumbing code, required to have a particular type of cover on it to prevent people from falling into it. This particular pit did not have that cover. So while they were trying to figure out what was going on, why the hole was overflowing with water, he falls into that pit, and with his right foot, the water, which is again about 250 degrees Fahrenheit, goes over his shoes, and he suffered very, very severe burns on that foot, which eventually required him having a skin graft procedure.
So with injuries that severe, did he immediately get medical attention and retain Spar and Bernstein?
Yes. So fortunately for him, he couldn't exactly walk on that foot because of the burns. He took himself to the hospital, and he got the treatment that he needed to get. And then he called us, and then we stepped in at that point in the case. He actually went home first. He went home, and then he took himself to the hospital.
Wait, so you say he took himself to the hospital?
Yeah, he actually, he was there working, and his employer was there as well. And his employer didn't take him to the hospital, and he didn't call the ambulance. He basically picked himself up, whether he hopped on his left foot to his own car and then drove using that left foot, he drove himself to the hospital afterwards.
So who, in this type of case, who'd you sue on his behalf?
So although there's quite the case to be made against that employer, especially for, failing to even call an ambulance on his behalf, unfortunately, there's something called the workers' compensation laws in New York. And the workers' compensation laws essentially prevent employees from suing their own employers. There's policy considerations, behind that. New York State and other states, they want to promote hiring, and as a result, they make employers immune from being sued by their employees for anything that they do wrong. But fortunately, we were able to sue the building owner because they were the ones by law required to have a cover on that pit. So we were able to bring a lawsuit against them for what we call as the negligent failure to remedy a dangerous or hazardous condition on the property.
Okay. So what do you have to prove in a case like this?
Well, when in cases where you're talking about, defective or hazardous conditions on a premises, the owner is they have a non-delegable duty. That means they can't delegate or, point fingers on someone else for what happens on their premises. They have a duty by law to ensure that everything is safe for people to come in, to come out, to work in this case. And we made the argument that they failed to do so. We had an expert submit a report, cite all the violations that they had by failing to have a hole. And all we were really required to show is that they were aware of this violation and that they failed to remedy it in time. Fortunately, we did have testimony from the employer himself, who said that on previous occasions he had warned the building that there was a cover required to be on this pit and that they failed to take action. So we were able to show that the building had what we call notice, or knowledge that there is a problem here, that there is, potentially this dangerous condition on premises where someone can get hurt, and that they failed to remedy the same. And that failure to do so eventually led to my client falling in and sustaining severe injuries to his foot.
Okay, David, can you go into a little bit more detail about the expert that you hired?
Here at Spar and Bernstein, we hire the best of the best experts wherever they're needed, whether they're medical experts or, in this case, we hired an engineer. We hired a professional engineer who actually was able to review the applicable statutes, the laws, the regulations applicable to buildings such as this and to boilers such as this. And he was able to determine in his report, in his investigation, that they violated the New York City plumbing code, that they violated other applicable provisions such as the labor laws by failing to have a cover on this pit. There was a specific type of cover that was required, diamond steel plate cover. There was also, it had to be a load-bearing cover, so it was able to withstand a certain amount of weight. And using that report, we were able to counter many of the defendant's arguments and leverage our position far more favorable.
Please tell me, what is comparative negligence?
So comparative negligence is actually very relevant in cases like this. This is what we label as a trip and fall case or a premises case. Comparative negligence is when the person suing, the plaintiff who we represent, bears some fault or responsibility for the happening of the accident. Now, obviously, our position as being advocates for our client is he did nothing wrong, she did nothing wrong, they did nothing wrong. But, the defendants, obviously, they have to represent their clients. So they're always going to point fingers. Well, your client should have been X, Y, and Z. And then as a result of his failure to do so, he was responsible for his own accident. So in this case, they claimed, among other things, number one, he wasn't wearing the correct shoes. So as a worker trying to repair a boiler, he was required to wear steel toe boots. They claimed, and the hospital records basically corroborate that he was wearing sneakers, which exacerbated, they claimed, his injuries, his burns. The steel toe boots, they say, would have prevented the burns. They also said that, well, you've been on that site before. You've worked on that boiler before. You knew that there was no cover on that hole, and you should have exercised caution in avoiding it.
I need to know what you guys did to counter those.
Yeah, so the main thing that we said is, listen, you guys can point as many fingers as you want, but what you can't dispute is that pit was required to have a cover. And if that cover is there, we're not here today to discuss this injury. If that cover was there, no matter whether the water was overflowing, no matter the temperature of the water, no matter what shoes he was wearing, he wouldn't have fallen in and the injuries wouldn't have happened. But comparative fault is a very strong tool that defendants have at their disposal. Practically how it works is the judge or the jury, depending on the context, would assign a percentage of fault on the defendant and a percentage of fault on the plaintiff. So the jury might come back and say, well, listen, the defendant should have had a cover, but we still think that the plaintiff should have exercised more caution, knowing that there was a hole there, that it was uncovered. And as a result, we're going to place 60% of the fault on the defendants and 40% of the fault on the client. How does that work? Whenever the jury comes down with a verdict, so let's say the verdict is $1 million, that $1 million verdict will now be reduced by the percentage of fault. So since plaintiff is 40% at fault in this hypothetical, he would get $1 million minus 40%, so minus $400,000, he would walk away with $600,000, representing the fault of the defendant's percentage.
Right, and that's exactly what happened in this case. Was the client actually determined partially liable for the accident?
Well, that was a risk that we would have had to overcome at trial, which, we're always confident that we're going to overcome these issues. Defendants try to make these claims all the time. There was a risk that our client did not want to roll the dice with at trial, and as a result, we were able to negotiate a settlement of over $600,000 pre-trial before we got this issue in front of a jury.
All right. So how is your client doing now? Is he able to work?
He's working, but he's working on lighter duty. So instead of doing all the heavy lifting tasks, he's pushing paperwork now. He's still getting paid. He didn't really lose any income. So there wasn't a claim to be made for any loss of income. It was just the pain and suffering that we had to deal with and the issue of any comparative fault, if any.
All right. Well, any last words that you want to talk about with the case?
I just want to say that, we handle all types of cases, from car accidents for premises cases, for trip and falls, for slip and falls, anything under the sun when somebody is injured. And if there's fault to be had on anyone, us here, the attorneys at Spar and Bernstein, we're going to find someone to hold responsible, and we're going to ensure that our clients, no matter the injuries, no matter the case, are going to get fully compensated for any wrongs done against them. And we're happy to report that on this case, we were able to get him a very nice settlement of over $600,000.
Amazing work as always, David. Your client was definitely lucky to have you and the team, the Spar and Bernstein team, fighting for him. So everybody, to get in touch with David or any of the other talented attorneys here at Spar and Bernstein, make sure you call 1-800-529-5465. That's 1-800-529-5465.